Good morning, everyone, and thank you for tuning in to the Higher Level High Notes today. My name is Erin Kopek, and I am the Director of Marketing with Higher Level. Today, we are going to talk about employee leave in times of COVID-19. And today, we have John Gilbert with Sandberg Phoenix that's going to give us all the ins and outs and educate us on what we need to know at this time. Just a few housekeeping things before we get started. This presentation will last about an hour. You all are set up in listen-only mode. You will have an opportunity at the end of the presentation to pose questions. You will see a questions box at the bottom of your GoToWebinar panel. So feel free to ask questions as we wrap up, and we will leave time for you to do so. So before we get started, I would like to introduce John. John Gilbert is a shareholder in the Sandberg Phoenix law firm working at its office in Edwardsville, Illinois. John has practiced since 1975 and concentrates his practice in labor and employment law and litigation, as well as civil rights defense litigation. John has also been a lecturer at Southern Illinois University, Edwardsville for nearly 40 years and serves as the hearing board chair for the Illinois Attorney Registration and Disciplinary Commission. I do want to throw out John's contact information if you all have any questions following the presentation. He has provided his phone number at 618-659-9526, and John will also remind you that at the end of the presentation. Again, thank you all for tuning in today, and we look forward to what you have to share. John, I pass it off to you.
Great, thank you very much, Erin, and good morning, everyone. On behalf of Higher Level and Sandberg Phoenix and myself, thank you for joining us this morning. What I plan to do is take you through an outline which Erin will place up so you can see it. There's the beginning, and I want to thank her for correcting the typo that I had in the very first entry there. And we'll get started. We'll leave some time at the end for questions because, as all of you know, this is a very fluid situation. Many of us did not expect to be where we are at this time of the year and this point in the pandemic, but we are not seeing an amelioration of cases, and the challenges are still there, especially on the legal front with regard to managing employment issues that arise out of the COVID-19 pandemic. There are pending, I should say, negotiations in Congress right now, as everyone is aware, about a new stimulus package. Whether or not the end result of that will affect any of this is anybody's guess, but I would urge you at all times to stay current on what's going on. Be sure to stay in touch with your HR professionals and your legal counsel so that you can get guidance through this minefield of COVID-19 legal issues. I wanted to start in talking about leaves in the time of COVID-19 with the Family Medical Leave Act leave. Of course, it's available, as always, for serious medical conditions of employees or family members who fall within the FMLA purview. Of course, you have to have 50 employees in order to have employees eligible to use it, but it's available. The major point under the standard FMLA Act leave is that under the Families First Coronavirus Response Act, or the FFCRA, which was enacted back in March and took effect in April, that if your employees qualify for FFCRA leave, they get that first before you can begin to run the clock on FMLA leave. I haven't, in my own experience, I have not had a lot of clients with employees who have gotten into standard FMLA leave with respect to coronavirus. Other issues, yes, but keep in mind that under the regulations of the FFCRA, if it applies, that goes first before standard FMLA leave. Now, for some of you, if you're small enough, the FFCRA may not apply. And also, if you are a public entity with first responder employees, you have the option to opt out of the FFCRA and not apply its provisions to first responders. I've only had a handful of municipality clients that have done that because they want to be able to extend the provisions to first responders, but in some cases, especially smaller municipalities, they've chosen to opt out in order to have sufficient coverage for police and fire and telecommunicating. So FMLA leave still alive and well, but don't use it first. Look to see if FFCRA applies. Now, apropos of the FFCRA, of course, is the Emergency Family Medical Leave Act under the FFCRA. And that, of course, allows certain employees of covered employers to take up to 12 weeks of expanded family and medical leave, 10 of which are paid. But the condition is that the employee is unable to work due to a need to care for his or her son or daughter, whose school, place of care, or child care provider is closed or unavailable due to COVID-19 related reasons. This has been invoked often, but the conditions are very carefully laid out, not just in the statute, but also in the regulations, which I just indicated. Many of us in the profession thought that these all would have been used up in the beginning times of the pandemic, but keep in mind, these benefits are available through December 31st of this year. And if the coronavirus pandemic continues with its surges, as we have seen, I would not at all be surprised if this isn't extended into 2021, but we'll see. Another feature of the FFCRA, of course, is the Emergency Paid Sick Leave Act provisions. This is the provision under which employees get 2 weeks of paid sick leave if they are unable to work. And keep in mind, if they can telework, they're not eligible for this. And we've had some experience with this since the spring, and I think most employers understand this. There are 6 conditions under the EPSLA provisions of the Families First Coronavirus Response Act. Most people are familiar with that, but very quickly, it's if they're subject to a quarantine order, if they've been advised by a healthcare provider to self-quarantine, if they're experiencing symptoms and they're seeking a medical diagnosis, if they're caring for another individual who is subject to a quarantine or isolation order, or who's been advised to quarantine, if they're caring for a son or daughter whose school, place of care, or child care provider is closed or unavailable due to COVID-19 related reasons. And of course, that's in there so that those people who fall under that provision get their first 2 weeks of leave paid for. Then the EFMLA kicks in and they get the next 10 weeks at 2/3 pay. And then the 6th reason is any other similar condition that the HHS secretary has designated. So, these are still available, and you may have employees who haven't needed them until now, or who may require them before December 31st, 2020. And I have seen with my own practice employers who made it through since the spring, and whose employees, or some of whose employees, are now contracting the virus with recent surges. And if you're in Illinois, you will know that we have a continuing yo-yo effect of high number of cases, then mitigation measures are imposed, cases go down, then the mitigation measures are lifted, and then cases start to go back up and the mitigation measures are reimposed. And in those times when the cases go up, my clients have been seeing an increase, not huge, but an increase in employees who contract the virus. Therefore, they have had to go back into applying the benefits under the FFCRA, which again are still available through December 31st of this year. So you may be facing those through the end of the year, and as I indicated, maybe an extension if we continue to see the sort of case surges we have seen. I saw a statistic this morning that 38 states are experiencing, quote, surges, close quote. And so we're not close to being out of this. And these provisions are provisions we're going to have to pay attention to for employees who need leave. Now, again, be sure to check with your HR advisors as well as your legal counsel to make sure you're covered by these statutes, and apply them in accordance with the regulations issued by the Departments of Labor. And we'll talk about some of the other governmental regulations as we go through this. One of the important features under the FFCRA related both to the EFMLA and the EPSLA. And by the way, before I talk about that, there are proof requirements that you are allowed to ask your employees to provide. The regulations are somewhat loose with regard to obtaining proof from healthcare providers. And so you can ask employees who the doctors are, who the healthcare providers are. You can also ask employees who are seeking EFMLA leave to name the daycare providers who have closed down or who aren't available, even if they're family members. But it's very difficult and it's not necessary for an employee to provide certification or for you to check in with the healthcare providers. And if you're not able to because they're so busy, that does not prejudice the employee. So at least I, in advising my clients, have taken a pretty liberal stance in terms of what's required from the employee to be able to establish what the employee needs to establish in order to obtain the benefits under the FFCRA. It's under the traditional Family Medical Leave Act leave. I think you can be a little more demanding, but I think you're going to find that with all these surges, it's not going to be as easy as it used to be before the pandemic hit last spring. Now, what about employer paid leave policies? Most employers have leave policies, whether it's the traditional sick leave, vacation leave, personal days, or whether you lump everything into a PTO plan. Most employers have some type of paid leave available. Your employees can use that, and you can encourage them to use it, and even depending upon the conditions which are specified in your policies, you can require them to use it. However, under the FFCRA, if it applies, you cannot require your employees to use that leave until they have gotten, I like the word received better, until they have received the benefits under the FFCRA. So it's entirely possible, and I've actually had this happen with clients, where the employee gets the 2 weeks of paid leave, then takes FMLA leave and substitutes, if your policy provides for this, paid leave for the FMLA leave, and has used up all their sick leave, and if available, personal days and vacation, in order to make sure they get enough pay to be able to get through the entire period if they have that leave available. So pay attention to what's in your paid leave policies and even unpaid leave policies to be able to afford employees the opportunity, especially if they are victims of the COVID-19 virus, to be able to take the time off they need and get well, heaven hopes, and get back to work. So we're still, even though we've had months of experience with this, we're still going through what I call the first wave of legal issues, i.e. dealing with traditional FMLA leave, EFML leave under the FFCRA, EPSLA leave under the FFCRA, and the application of your own leave policies. And it's can be a minefield, although I think with, as I've indicated, good HR advice and good legal advice, you can get through it. Now, another issue that has arisen is, where does ADA fit in all this? And it does fit in this, because you may have employees who either are already being accommodated under the ADA, or who will seek accommodation under the ADA as a result of having been infected with the virus. Most of us know, if you've been paying any attention at all to the history of what has occurred during this pandemic in the United States and in your own state, that people who are infected by this virus range from asymptomatic to mortal, or to death. And there is a lot of evidence that this virus, depending on the virus load that people receive who are infected, and their own bodies and immunities and blood types and all these other factors that we're discovering go into a person's experience who's infected, they may end up with qualifying disabilities under the ADA. They may have lung issues, they may have heart issues, they may have chronic fatigue syndrome. There's just a range of disabilities that can spring from an infection with the coronavirus, COVID-19 virus. So you've got to be prepared for that. Employees are going to request accommodations under the ADA as a result of disabilities that result from infection with COVID-19. So what do we do about that? Well, we do about that what we would do with any other disability under the ADA. And that is, of course, you engage in the interactive process to determine whether or not there is a reasonable accommodation for that employee so that he or she can perform the essential functions of the job with or without accommodation. And leave is one of the ways of reasonably accommodating someone under the ADA. So I've had a couple of cases where employees have contracted the virus, taken the 2 weeks of EPSLA. This is quite an alphabet soup we have here. But they've taken the 2 weeks of the EPSLA They then have gone on family or on FMLA leave if they haven't been available, if they haven't qualified for the EFMLA, but they've gone on FMLA leave and either substituted paid leave under employer policies, or they have piggybacked, depending upon what the policies provide. Then they've exhausted all their leave. They are diagnosed with a disability that has arisen out of the COVID-19 infection and have sought reasonable accommodation for the resulting disability. And one of the options is additional leave, whether it's intermittent leave or it's being able to continue to work remotely, or whether it's just some additional leave, even unpaid. All the options are still out there. And usually once somebody's exhausted FMLA leave and they still seek leave as a reasonable accommodation under ADA, it's a little more difficult to make out a case that that's a reasonable accommodation, especially if attendance or being present in the workplace is an essential function of the job. Excuse me. This is where telecommunicating and remote work can be very, very beneficial with regard to accommodating someone with a disability under the ADA. We have found in the legal profession that remote work has been a smashing success, and it is also working in a lot of other industries. So consider that as a reasonable accommodation, because there are going to be employees that will end up with disabilities under the ADA as a result of having COVID-19. And it's also true that you'll have associational claims, and you'll have probably not too many perceived as claims, but definitely we'll see associational claims because of family members who have COVID-19 that the person may be caring for, etc. So keep in mind, you're still going to be conducting interactive processes under the ADA for people who return to work with disabilities that arise out of their experience with COVID-19. Now, one other area that I heartily recommend that you pay attention to, consult with your HR professionals and your legal counsel about, and that is state leave laws. I originally had this as Illinois, but I know that some of the attendees that have joined us this morning might not be from Illinois. So I would suggest that you pay close attention to your state leave laws. Some leave laws will impact how you handle leave, especially after employees have exhausted, if they apply, FMLA, the EFMLA, the EPSLA, and your paid leave policies. If you're into your paid leave policies, your state laws may have an impact on how those are administered. For example, in Illinois, you're entitled, it isn't quite this simple, but in Illinois, an employee is entitled to use approximately half of accrued leave for family member sick leave. So, if you have something like that and the employee is down to using the leave that you provide under your leave policies, that employee in one state might not be able to use half that leave for illness of family members. In Illinois, they are. So, you have to keep in mind that there are state leave laws that have an impact on how you approach the COVID-19 issues when you get through these other levels of protection, again, assuming you're subject to the FFCRA and the FMLA and the ADA as well. Okay, Aaron, if you wouldn't mind going to the next slide, thank you very much. Most of the questions that I am getting these days are return to work issues. So I want to spend a little time on that with you. Not only are we still seeing questions we saw in the spring when all this started because of the continued surges and the lack of getting control over this pandemic across the country. And honestly, I think, for what that's worth, that we're not going to see this under control for quite some time, and probably not until we have a vaccine that is available, that is distributed, that is safe and effective, and that begins to provide the protection for citizens across the country that a vaccine, we hope, will provide. And as optimistic as the government is, or some people in the government, I should say, and even the companies that are developing the vaccines seem to be, it's going to be a while, and it's going to be into next year, I believe. And then, of course, takes time for that immunity to work. So I think we're still going to be dealing with these threshold issues that we dealt with in the spring and that were addressed in the first half of this presentation, all the way up until we get this pandemic under control. So when things began to calm down a little bit before recent surges and businesses were opening back up and people were coming back to work and people were being brought back into offices from remote work, we began to see return to work issues. One of those issues, which I received many phone calls about, were employees who said to their employers, I'm afraid to come back to work. I'm afraid to come back to work because I'm afraid to get out of the house and to go back into the workplace for fear of contracting the virus and either suffering it myself or bringing it home to my family and infecting my family members. And that generalized fear, of course, was based on what we all think about. That is, you get exposed to other people, which is the way that this virus is passed on, most likely. And now that we're learning that 6 feet may not be enough for social distancing, and that the aerosols of the virus can be suspended in the air for hours, and depending on how much is in the air, that goes into the risk. And there's still so much uncertainty. There are a lot of employees who don't want to come back to work. I've experienced that in my own law firm. We have staff members who want to work from home forever until this thing gets under control. So some employees will present a generalized fear of contracting the virus as a basis for saying they don't want to return to work, or that they can claim some leave benefits, depending on what your leave benefits provide. Well, it's become very clear that a generalized fear is not a sufficient legal basis for employees to claim FMLA leave, EFMLA leave under the FFCRA, or the emergency paid sick leave under FFCRA. A generalized fear is just not enough. It certainly is understandable, and it's real, because I have seen employees who express genuine concern about contracting this virus when they come back to work. But generalized fear of contracting the virus alone is not sufficient to trigger any of these leave options, unless under your own leave policies, you're willing to grant the employee time off. I've had clients who've granted employees unpaid time off. I've also had many employees, including my own law firm, who have ramped up remote working so that valuable employees can continue to contribute, even though they don't otherwise qualify for these leaves, but they're still afraid of contracting the virus. Primarily, that's based upon people who don't follow the mitigation efforts or the mitigation recommendations of washing hands, wearing a mask, social distancing, and concerns that those things are not sufficient. But bottom line is, the generalized fear of contracting the virus is not sufficient for employees to invoke these legal leave coverages by and large. All right, temperature checks. That's something that has become very popular for employers to implement. And it's a brisk business for those who provide these types of temperature checks. And I've seen plans all the way from employers who require employees to self-check temperatures and keep a log. I have seen plans where employers institute a kiosk where the employee where there's another employee who, takes their temperature with a thermal temperature taking device. How's that for high tech? The explanation, that is. Or who use even biometric type measurements. I have one employer who I discussed this with last week, who actually has a vendor who comes in. There's no human contact, but they stop at a kiosk. There's facial recognition technology. There's thermal imaging to take the temperature. And if the employee's temperature is under 100.4, the employee is allowed to come to work. They sign in either with facial recognition or fingerprint, and they're allowed to come to work. They have to wear a mask, and it just really depends. Their employers have a wide range of techniques to screen employees when they return to work. And there are a lot of employers who needed employees to return to work. I have a number of social service agencies I represent who simply have to have their employees at work. They can't work remotely when you have to interview clients of agencies that provide Head Start, for example, or other types of family services, and have to make home visits. I mean, you can do some of those remotely, but at any rate, there's a wide variation of return to work screening. And one of the most popular is temperature checks. Now, so the issues, of course, that come up are, well, can you do this? Is it an invasion of privacy? Does it run afoul of Title VII and other civil rights legislation that protects employees? Does it run afoul of the ADA? Well, fortunately, we have guidance from the EEOC which they keep amending frequently, but they do have a really good technical assistance question and answers document on the US EEOC website that pretty much says you can take temperatures and that it's not a violation of the ADA to do temperature checks. And you can record them and you can then take action if the employee has symptoms, and we'll talk about that in a minute. But right now, the EEOC does allow temperature checks. It's a good idea to consult the technical assistance Q&A document that's on the EEOC website, because it goes into great detail about the information you can request, the type of screening that you can undertake, whether or not you can tell your employees to stay at home if they have symptoms, whether or not you can require a doctor's note certifying that employees are fit for duty, and yes, you can. There are just a host of questions and answers that the EEOC gives in this technical assistance document that really provides great information for employers. We don't have time to go into all of it, but they even address the issue of whether you can administer a COVID-19 test. And so be sure to consult that. I think it's a good idea. They rely heavily on CDC guidelines, but it's a great document that'll answer a lot of questions about what you can do with regard to return to work issues from the statutes that the EEOC implements. Now, one issue that has reared its ugly head with regard to temperature checks and other return to work techniques that employers have adopted to screen employees is this awful statute that we have in Illinois called BIPA. That's what the BIPA, that's how we call it, but what it stands for is the Biometric Information Protection Act. From an employer standpoint, this is one of the worst pieces of legislation enacted in the state history of Illinois. And that says a lot, because Illinois has a lot of employer hostile legislation on the books. But this one sort of takes the cake, and it's become a favorite of class action plaintiffs' attorneys across the country. The claims that have been filed under this statute have been filed all over the country as plaintiffs' lawyers who represent employees have tried to shoehorn all sorts of practices that employers undertake to identify and collect information on employees into this statute because the Illinois Supreme Court made it really easy to claim damages under this statute. And, obviously, as you can probably tell, I represent employers. I don't represent employees. So you'll have to forgive my bias, but this statute has become sort of the new darling for plaintiffs' attorneys who represent employees against employers. And so under the Biometric Information Protection Act, you have to be alert to the possibility that if you are measuring people's temperatures, that somebody is going to allege that those practices, especially if you identify your employees by scans of their faces or their fingerprints or retinal scans or some other type of biometric information collection technique, is going to expose you to liability under BIPA. Now, before you panic, there are ways to address that risk. And one of those ways is to make sure that you disclose to your employees that you're collecting biometric information, what you're going to do with it, how long you're going to retain it, and when and how you're going to destroy it. And then also how you are, and also get their consent to do it. That will go a long way toward relieving you from potential liability for violating the statute. Is it going to give you 100% protection? Probably not, because attorneys are very creative. And while you may not lose these cases, you might end up getting sued under BIPA, even if you're not an employer in Illinois. So keep in mind, this is a risk. So make sure you consult with your legal counsel and your HR experts to make sure that you have a proper informed consent document for your employees to execute before you institute any type of employee screening when they return to work, which has any biometric information collection at all. Now, there are other states that have similar legislation, but they're not as wide-ranging or wide open as the Illinois statute. So just make sure you're mindful of this risk and this issue so that you can protect yourself. And you get a good consent form. You disclose what you're doing to the employees. Now, they may not consent, and if they don't consent, you might have to find an alternative way of screening them, which means, you know, somebody stands there and shoots their forehead with a thermal, thermometer, or they might even have to take their temperature on their own and write it down and give it to you. But just be mindful that there's this risk out there under BIPA, under the Illinois statute, that needs to be managed and addressed, lest you expose yourself to a potential liability under that statute, which, as I indicated, has become a darling of plaintiffs' employee attorneys. Okay, now, what happens if your employee tests positive when you screen them, or screen him or her, or them? All right, there's a range of actions that you can take. Number one, without hesitation, tell them to go home. So if they're running a fever of 100.4 or higher, or if they are exhibiting any of the myriad symptoms of COVID-19, which seems to be expanding all the time, if you're a regular viewer of the CDC website, as I am, and unfortunately, we're heading into a season where you have an overlap of COVID-19 symptoms, allergy symptoms, and now the flu, the seasonal flu, all of which overlap. So if you see those symptoms in an employee in a screening test, number one, send them home. Number two, contact your local Department of Public Health for guidance. Not only is that the right thing to do for the protection of the employee and your other employees, but it's also the right thing to do to help provide legal protection with regard to anybody who gets sick and then decides they want to sue you or file a workers' compensation claim about it, which I'll address in a bit. So send them home, determine whether or not the leave requirements or the leave entitlements they have apply and how you're going to do that. Contact your local Department of Public Health or your state Department of Public Health, but you are allowed to send those employees home and then start determining what policies apply, what laws apply, and also if they have exposed any of your other employees. So you got to do some contact tracing, whether you do it yourself or you have the Department of Public Health do it, because I know here where we are in Madison County, the Department of Public Health is stretched very thin for contact tracers. So my employer clients who have had positive cases in the workplace do their own contact tracing, and they'll find out who that employee has been in contact with in the 14 days before their symptoms appear. Of course, you also should send them for a test to determine whether or not they have COVID-19. And then when you get that result back, of course, proceed with or continue contact tracing and have those people quarantine. I have one client that runs a daycare center. One of their teachers turned up with COVID-19 and they had to shut the whole place down for 14 days so that everybody could quarantine. And, you know, it was a nightmare. But it's very important to follow up on those techniques and to follow the recommendations of Department of Public Health contacts that you make in order to not only protect the health and safety of your employees, but also to provide a level of legal protection should you get sued or employees file comp claims. You know, it's a kind of a shame that we have to think about that, but that's really why you have a lawyer talking to you this morning. Now, one of the issues that has been discussed among employment attorneys in looking toward the future so that we can advise clients is what happens when a vaccine is successfully developed and implemented. Well, first of all, hallelujah. But secondly, what about can you require your employees to be vaccinated against COVID-19? A, and B, what happens if they don't want to be? You know, 40% of people surveyed, if you can believe these surveys, indicated they won't take the vaccine until they're entirely convinced that it's safe and effective. 60% say, I'll take the risk. I'm among that 60%. But what happens if we have a successful vaccine and you want your employees to be required to take it? Well, fortunately, we have some experience with flu vaccines to give us a little guidance. Now, can we depend on this 100%? No, you never can. Because again, lawyers, judges are very creative in trying to establish liability. So we can't guarantee this. This is why you have to stay on top of this almost on a daily basis. But if a vaccine is developed and you want to require your employees to have it, you can. However, there's a big however. If your employees have legitimate reasons not to get the vaccine, you will have to address that. So for example, you're going to have employees who are going to have health reasons why they can't get the vaccine, in which case you're under ADA and you're going to have to determine, is there a reasonable accommodation for this employee not to get the vaccine? So in other words, can they work in a place that is socially distant? Can they work from home? You know, are there other accommodations like we do for people who can't get flu shots when they are when they have a disability? And hospitals, for example, I have hospital clients who require their staff, all their employees, to get flu shots every year. Some people can't, so they reasonably accommodate that if at all possible. So that's an issue to keep in the back of your mind if there is a vaccine developed that works. Second, you're going to get religious objections to vaccines. If they are bona fide and pursuant to, you know, sincerely held religious beliefs, you may have to accommodate that. Now, under the law, the accommodation is sort of de minimis. In other words, you don't have to go to the same extent you would have to go to for ADA. So the proving an undue hardship is a little easier when there's a religious objection, but if you can accommodate, you should. Now, of course, there are people who are opposed to vaccines, period, the so-called anti-vaxxers. I don't like that term, but some people have legitimate opposition to vaccines. And again, that's really not, if it's not a religious belief, it's not a disability issue, that you don't have to accommodate. Okay, the final substantive issue that I want to address quickly because we only have about 10 minutes left, and I do want to take some questions if there are any, is workers' compensation. You may get, I should say, workers' comp claims for employees who contract the virus and who will allege they contracted it at work or in the course of or arising out of their employment. I put first responders on here because that's the biggest risk category. Police, firefighters who go out to scenes and may contract the virus from people with whom they come into contact in fighting a fire, or if it's EMTs or paramedics, they come into contact with people who might have the virus whom they don't even know. Those are going to be workers' comp issues. In Illinois, there's a rebuttable presumption that first responders have contracted it at work. If you're not a first responder, then the employee still has to prove that, and if you fight the first responder, they still have to prove that they contracted it in the course of or arising out of employment. But workers' comp is an area where you're going to see claims, if you haven't already, that employees are going to say they contracted the virus in the course of arising out of employment. I've seen a lot of these in my assisted care facilities and the nursing homes that we represent. Employees are getting the virus from residents who also are getting the virus from employees, I might add. But they're filing comp claims, and that's something you and your comp carrier are going to have to work on in terms of how those are going to be handled, and also what preventive measures and mitigation measures and loss prevention measures you're going to be able to take in the workplace and that your insurers will require in the workplace. And if you're self-insured, you know, all these different steps that are available are going to have to be explored and utilized. At the end of the outline, you can see here that I just put some very basic resources for you, but these resources are a storehouse of information and guidance. The U.S. Department of Labor has extensive regulations under the FFCRA. They were challenged in court, and so the US DOL very quickly responded to the court challenge and issued revised regulations back a couple of months ago, and those are now up to date. You can find just tons of information on the Department of Labor website related to the FFCRA and other COVID-19 related issues. I already mentioned the EEOC regulations and guidance at eeoc.gov. Again, tremendous guidance for employers in dealing with this pandemic and its implications for the workplace. State departments of public health should be consulted. The Illinois Department of Public Health, again, great information, dph.illinois, you can see there. And of course, the CDC website is rife with valuable information on what to do in the workplace. And your local departments of public health, your county departments of public health, all are extremely helpful in guiding you, not only in dealing with this pandemic in the workplace, but also if you follow what they tell you, it will give you some level of legal protection in the event you have claims. All right, thank you. What questions do we have, Erin?
All right, thank you, John. All right, everyone, now's the time to use that question box function at the bottom of your GoToWebinar screen. Feel free to type in there. We will give you a couple of minutes. If there are anything that you have questions on and would like covered a little bit more, we have just a few minutes left. And I want to thank you, John, again. Very thorough, great information to share with us today. I know especially in the area that our offices are in and where we currently work out of. It's definitely very relevant.
Well, thank you. I just can't emphasize enough staying on top of the developments. That's really important because these issues are developing constantly.
Absolutely. And I do want to let everyone know that attended today, we will be sending out the recorded presentation later on this week, and you will have it in your inbox. So keep a watch out. Again, if you have any questions, feel free to reach out to us at Higher Level, or John, I'm sure he would be happy to answer any questions for you as well. But I do not see any questions coming in. So we will let everyone get back to your day. And thank you again for joining us.
Yes, thanks everyone. Thank you, Erin.
Thank you. Have a great day.